My name is Alyn Ware. I'm the Global Coordinator for Parliamentarians for Nuclear Non-Proliferation and Disarmament, and an international consultant for the International Association of Lawyers Against Nuclear Arms, which was instrumental in taking the case to the International Court of Justice, the advisory opinion on the legality of the threat or use of nuclear weapons. What we will be having is a bit of an introduction to the issue with a video, a few words from myself just to set the frame for the topic, which is on re-examining the 1996 advisory opinion on the basis of where we are now on international law and nuclear weapons, and then reflections on this, on the doctrine of nuclear deterrence. We're going to start off with a video, and the video is a short one from the Atom project, which is a new project which was launched on August 29th, which is the International Day Against Nuclear Tests. It was established by a consensus UN resolution in 2009 at the proposal of the government of Kazakhstan. And the date is significant because it was the date in 1991 that the semi-planetary nuclear test site, the Soviet nuclear test site, was closed down. And on that date this year, a project was launched called the Atom Project, Abolish Testing Our Mission, which is using the experiences of the catastrophic humanitarian and environmental consequences of the nuclear tests to demonstrate the imperative for nuclear abolition, based very much on the experiences in Kazakhstan, but they will be broadening out and including experiences of nuclear testing in other regions. So this is just a new initiative focusing on the humanitarian consequences of nuclear weapons use. And as you saw, many of the people that you saw there are second generation victims, i.e. they didn't have the radiation themselves, but their parents. They're now getting third generation victims from the nuclear tests in Kazakhstan. I'm going to give just a little introductory background to the International Court of Justice advisory opinion in international law. Many of you know the decision from the International Court of Justice back in 1996. And of course, the International Court of Justice is the supreme judicial organ in the United Nations system, so in a sense is probably the most authoritative decision on the issue of nuclear weapons and international law. The primary decision, I mean the whole decision itself was to be taken in its entirety, but the dispositive, which had the conclusions, had the critical decisions from the court. And most of you already know this. The decision was that the threat or use of nuclear weapons would generally be contrary to the rules of international humanitarian law applicable in armed conflict, and in particular the principles and rules of humanitarian law. Then it went on, and this has been one of the most disputed and argued phrases from the decision: the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self-defense in which the very survival of a state would be at stake. And this has been argued in a number of ways, what this actually means. Does it give an openness to the existing nuclear deterrence policies, or does it place restrictions on nuclear deterrence policies, and if so, in what way? The nuclear weapon states themselves have generally followed up with comments on this, in that their nuclear deterrence policies are consistent with the decision of the International Court of Justice. Most notably that the United Kingdom did that in an analysis of the decision undertaken by the Attorney General, where they said their policies were consistent. So some people said, well, it wasn't really doing much if it didn't address nuclear deterrence decisions. This was a cartoon that came out in New Zealand, you know, about the judges going, oh yeah, how bad are nuclear weapons? Oh yes, they are bad, they're obscene, they're immoral and illegal, they must never be used, well, except when strictly necessary. So some people have sort of like diminished the decision of the court as being, well, a nice sort of exercise, you know, but really not applicable. Others, however, say it is a lot more applicable, and in fact, that the nature of the law and the relevance of international law to nuclear weapons has actually turned the Lotus Principle on its head with respect to nuclear weapons. Now, those of you know the Lotus Principle, it came out of the Lotus case in 1927. It was a French ship, the Lotus, smashed into a Turkish ship and some lives were lost. And the French were putting forward a principle of international law that hadn't been codified into a treaty and saying it was there, the permanent court said, well, if it's not specifically prohibited under international law, therefore it's permitted. And that has sort of become a principle called the Lotus Principle. That which is not specifically prohibited under international law is permitted. And applying that to nuclear weapons prior to the 1996 International Court of Justice Advisory Opinion, it basically gave the nuclear weapon states the capacity to say, well, there's nothing illegal in our policies. However, the court, in a sense, has turned that around by saying that the threat or use of nuclear weapons is generally prohibited, and that the only circumstance where they can't make a decision is the extreme case of self-defense when the very survival of a state is at stake. It actually turns it around and places a general prohibition on nuclear weapons rather than a general permission on nuclear weapons. In a sense, the onus is now on the nuclear weapon states to demonstrate which of their policies can actually be consistent with the decision from the court, and anything else would be prohibited. So it did actually create a new situation with regards to the general prohibition of nuclear weapons. There was, however, also a question raised, and the French and the US raised that and said, well, it's only advisory opinion, so therefore whatever the court come out with is not binding anyway. But in actual fact, what the court was doing was using law that is binding, customary international law. So the opinion was actually giving a statement of law which is binding on the states. And the court also looked at, in doing that, was looking at the laws that were already embraced in many of the military law manuals of the nuclear weapon states. In fact, laws which the nuclear weapon states agreed in the court itself that applied to them. So the aspect of whether the decision is binding or not is actually not relevant. The law that the court was dealing with is binding on the states. And then if you look at the general prohibition, the court also said that even in the extreme circumstance, it doesn't remove the applicable law to nuclear weapons. Humanitarian law still applies even in that extreme circumstance. So even when the very survival of a state is at stake, then one has to look at proportionality, one has to look at discrimination, one has to look at the rules of neutrality, and the court, in a sense, it said, well, we couldn't actually see how nuclear weapons could be used even in that circumstance legally. So some people have said it's more like the situation in the Merchant of Venice. In the situation in the Merchant of Venice, when the contract was to take a pound of flesh. Well, the permission was, yes, you can take a pound of flesh in payment for the contract, as long as you do not spill one drop of blood. So that's, in a sense, the situation. Well, perhaps nuclear weapons might be able to be used in the extreme circumstance, but they would still have to conform to international humanitarian law. And is that possible? The court could not find any circumstance where it might be possible, but nor could it say that they could rule it out completely. So since then, there have also been some developments. The 2010 NPT Review Conference, for example, reaffirmed not just that the use of nuclear weapons would cause catastrophic humanitarian consequences, but that all states need to comply with applicable humanitarian law at all times. The Red Cross has also moved on. The Council of Delegates of Red Cross and Red Crescent Societies in November 2011 reaffirmed the conclusion of the court, finding it very difficult to envisage how any use of nuclear weapons could be compatible with the rules of international humanitarian law, and therefore appealed to states to pursue negotiations for the complete elimination of nuclear weapons. And that brings me back to the court and to the unanimous conclusion of the court on the obligation for nuclear disarmament, because this one has no wiggle room. The unanimous conclusion was that there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. Now, those of you who know the Non-Proliferation Treaty can see elements of Article 6 in there, but this goes beyond Article 6 of the NPT. Article 6 of the NPT also has an obligation to pursue general and complete disarmament. That obligation is not affirmed in here, in fact it's split off. This, in a sense, takes away the position which we put for some years that nuclear disarmament relied on progress on general and complete disarmament. The International Court of Justice places no conditions on the obligation to pursue negotiations and conclude negotiations on nuclear disarmament in all its aspects. Now, that doesn't mean that there aren't conditions that are going to need to be developed in order to achieve a nuclear weapons-free world, and Ted raised those. But these cannot be seen as preconditions to starting the negotiations. That's the relevance and the implication of the decision from the court. Therefore, those conditions should be part of the negotiations. They shouldn't be preconditions to starting negotiations. And that's the key implication. There is relevance to nuclear deterrence. As I mentioned, the court did not condemn nuclear deterrence outright, but it did talk about the illegality of the threat or use of nuclear weapons. Of course, the question is raised as, well, what is the threat of use of nuclear weapons? This was clarified a little bit more because the court did not really clarify what they meant by the threat of use and how that related to deterrence. But this was clarified to some degree in the Vancouver Declaration, which was developed by a group of international legal experts in February 2011, where it looked at two types of threats: specific signals of intent to use nuclear weapons if demands, whether lawful or not, are not met, so a specific threat of use, and then more general policies of deterrence declaring a readiness to resort to nuclear weapons when vital interests are at stake. The Vancouver Declaration brought in a larger body of law that has developed since 1996. I do recommend it as a good basis to look in order to give a stronger indication of the imperative to negotiate for nuclear disarmament and therefore to seek alternatives to nuclear deterrence. So that's in a sense an introduction with the legal imperative to start the negotiations to address the conditions within those negotiations and to find alternatives to nuclear deterrence. The recognition, that this is an endeavour of all states and not just the nuclear weapon states, something which Des brought up the other day, was both in the decision of the International Court of Justice. It didn't say that nuclear weapons had a responsibility to work for nuclear disarmament. It was there is a responsibility, and the same is in the final document of the 2010 NPT Review Conference. So these negotiations should involve all states, not just the nuclear weapon states, or all interested states. And with that, I think we have a capacity to move to tear down the wall of nuclear deterrence. And I think we have a capacity to move to tear down the wall of nuclear deterrence